This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about why there is no right to med pay if the bill from the physician is less than the deductible, and why an assignment of claim only works if there's coverage for the amount of the loss, and why a deductible defeated a claim when the bill from the doctor was less than the amount of the deductible. In February of 2019, Lauryn Frazier, a minor, was involved in a motor vehicle accident. Frazier was a defendant resident relative insured under a policy by USAA Casualty Insurance Company, which provided personal injury protection benefits and medical payment coverage. Emergency Physicians, Inc. provided emergency services and care to Frazier as a result of the accident and charged $733 for its services. USAA applied the bill to the policy's $1,000 deductible, indicating in an explanation of reimbursement form that the bill was subsumed by the deductible. In USAA Casualty versus Emergency Physicians Group, the Florida Court of Appeals on July 26, 2024, resolved the dispute since the Court of Appeal was faced with an appeal from USAA that the trial court erred when it provided benefits to the assignee. Emergency Physicians, as assignee of Lauryn Frazier, sued USAA for PIP benefits, and USAA admitted coverage for the accident, but alleged that the emergency physician's bill fell below the policy deductible and as such was the full and complete responsibility of the insured. Emergency Physicians asserted that USAA's declaration page cannot be relied upon as evidence that Adams elected a deductible, and thus, because the deductible form was not executed, there was no evidence of a knowing $1,000 deductible election. The court was required to determine whether USAA properly reduced its payment of PIP benefits by imposing the $1,000 deductible. The trial court entered its order granting emergency physicians' motion for summary judgment and denying USAA's motion for summary judgment. The court found that pursuant to the statute, an insurer must offer the option of electing a PIP deductible to the named insured at the time the initial application is taken and prior to each annual renewal. And pursuant to deposition testimony, the deductible form was not provided to the named insured prior to the policy renewing. Therefore, the court concluded USAA did not comply with the statute. In its motion for rehearing, USAA argued that the deposition and affidavit testimony in the insurance contract were more than sufficient evidence to support its assertion that a deductible applied in this case, and that the emergency physicians provided no evidence to contradict the sworn testimony attesting to the accuracy and authenticity of the applicable insurance contract. The Court of Appeals agreed with USAA that the trial court's findings were contrary to the record evidence. USAA employees testified that the declarations page reflected Adams's choices. USAA testified that it sent the policy issue packet, which included the deductible form, when Adams first purchased her policy, and similar renewal packet was sent at each and every renewal period. Accordingly, the trial court's findings were not supported by the record. The affidavits and deposition testimony were sufficient evidence that Adams elected a deductible, and because a deductible form is not required, the trial court erred in granting emergency physicians' motion for summary judgment. Moreover, because emergency physicians did not contradict USAA's deposition and affidavit testimony, there are and were no genuine issues of material fact. The Court of Appeals therefore reversed the order granting emergency physicians' motion for summary judgment and remanded the case for entry of final summary judgment in favor of USAA. In my opinion, this case went through motions for summary judgment and an appeal over less than $1,000, the amount of the deductible chosen by the insured when the policy was acquired. Clearly, both parties expended more money on lawyers and court time than the amount in dispute. USAA established the insured selected a deductible and was therefore personally responsible for the first $1,000 of medical bills. Since the bill was less than the deductible, USAA had no obligation to pay. And because it went up on appeal, neither side won. USAA just lost less. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You could subscribe to the blog. It's free. And if you do, you'll receive notice of every blog posting and access to the more than 4,800 blog postings. You can also subscribe to the videos for free on rumble.com or on youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing to my Substack publication. Thank you for your attention.